Your child's father owes you retroactively $78,925 that he is paying on a repayment plan. And is it your agreement that his current child support obligation is $1,435?
Yes, ma'am.
And you have no problem with this order reflecting that Mr. Brown is not the father of the child, but Mr. Copeland is?
Correct, yes.
And it's the state's understanding parties have acknowledged that Mr. Copeland's full obligation, current plus retroactive, will continue after the child emancipates in September so that the full amount goes towards that retroactive judgment.
There's one thing, like I said, it was misunderstanding, and I guess I have to talk to you about that individually.
Before the court on the petition established, we did an order for DNA testing as one of the last things we did. And the court will note that the copy of the DNA paternity analysis has been, test report has been filed with the court at this time.
It's the state's understanding we have a full and final agreement in this paternity action. With the court having mentioned the DNA test report, parties are in agreement that Mr. Copeland is the biological father of the child. The presumed father, we're going to go ahead and adjudicate him as not the father in this order as well. We're going to have parents named joint managing conservators. The standard possession order, Your Honor, given the child's age, will be in the order only for reference purposes, but I believe it's standard, or as at the discretion of the child who turns 18 this September. Mother will maintain Tricare Reserve for the child for medical without reimbursement from the father for any premium. The father will maintain dental through his employer, and the child support in this case is going to be $1,445 beginning August 1st, 2024. And this is going to be based on testimony on Mr. Copeland's current employment and his VA disability award at 100%. We're also taking into account 2 other minor children. Additionally, Your Honor, parties have come to an agreement with regard to retroactive support going back to August 2019, 4 years prior to the date all parties were served in this case. And we're asking for a judgment, or well, agreeing to a judgment of $78,925 with repayment of $445, also beginning August 1st. And it's the state's understanding parties have acknowledged that Mr. Copeland's full obligation, current plus retroactive, will continue after the child emancipates in September so that the full amount goes towards that retroactive judgment.
Okay.
And that's all for the state, Your Honor.
All right, Ms. Griffin.
Yes, Your Honor, that reflects our agreement, and we're asking for the court to enter those orders.
All right, Mrs. Starra.
And we agree with that as well, Your Honor.
All right, then. Well, let's get some testimony from parties, because we're dealing with enough money to buy a really nice Tesla anyway, and get some testimony to confirm that from the parties. So, and ma'am, how you pronounce your last name, please?
Elo.
Elo. Okay, Ms. Elo and Mr. Copeland, will you both raise your right hands? And Mr. Copeland, are you there, sir? You can, I say you can turn. If you got video, turn it on. If you don't worry about it. I can live without video. I can't live without audio. So, at this time, both raise your right hands, please. Do you both solemnly swear or affirm the testimony you're going to give this court today is the truth, the whole truth, and nothing but the truth, so help you?
Yes.
All right, you're both officially under oath, and I'll let the state call you as witnesses, and obviously let the 2 attorneys cross-examine. You may proceed at this time, Ms. Mungat.
Thank you, Your Honor. Actually, Your Honor, I'll defer to parents' counsel.
All right, then I'll let each counsel call their individual clients, and then let the other cross. So at this time, Ms. Griffin, I'll start with you then. Thank you.
Thank you. I call Vernon Copeland.
Yeah.
All right, sir, can you state your full name for the record?
Vernon Christopher Eric Copeland.
All right, you may proceed, Ms. Griffin. Thank you.
Thank you. Mr. Copeland, is it true that your income that was calculated is based on both your employment and your disability rate?
Yes.
Is it true that your income per month is $10,237 approximately?
Yes, approximately.
And then after taxes, is it true that it is approximately $8,900?
Yes, yeah, approximately.
Okay. And with respect to the children that you have responsibility for that are biologically yours, is it true that you have two other children that are minor?
Yes, ma'am.
Is it true that you agree to pay the guideline rate considering those deductions and considering the deduction for dental insurance that you're providing?
Yes, ma'am. But I could also provide health insurance. Not an issue.
Sir, do you understand that my client is willing to provide health insurance and that is covered through her?
I understand.
Okay. And with respect to the orders, do you agree that you would pay the rate as stipulated by Miss Victoria Bongat as to your monthly amount?
Yes, but I do have a question about a modification for that. I don't know what the proper time to ask that, but
Sir, you probably need to run that by your attorney, please, and not on the record.
okay,
Lawyers don't like talking to their client about circumstances on the record. Okay, they like to do that in private. Thank you.
no problem, sir.
And are you asking for the court to approve the rate, the current rate and the retroactive rate limited to 4 years in accordance with the law for retroactive child support?
Yes.
Okay, pass the witness.
All right, Mr. Starr.
Yes. Mr. Copeland, did you hear Ms. Bongat read the agreement on the record?
Earlier, yes.
Yes, correct. And we discussed that kind of agreement before off the record, didn't we?
Right, yes.
Okay, and you had enough time to kind of understand that agreement, is that correct?
Well, there was one thing, yes, but there's one thing, like I said, it was misunderstanding, and I guess I have to talk to you about that individually.
Okay. Are you still currently in agreement with that though? Are
Not
you wanting the judge to
100%,
make
sir.
that an order?
Okay, tell you what, he says he's not in agreement 100%. Let's stop the hearing for a moment and I'm gonna let y'all get into a breakout room, Mr. Starr, and see if y'all can iron out what that difference is. And if not, then obviously, well, I haven't been tainted too much. So if I need to have a hearing on it, I'll have a hearing. But for right now, I'm going to stop this one and let you talk to your client in the breakout room. Okay,
Right.
sir?
So I'll just ask my client some more questions. He is in agreement now. If we could just kind of restart my little questioning of him, I think we'll be good to go.
All right, then. Well, I'll know for the record that Mr. Copeland's back in the main room here, and I'll go ahead and let you, and it was your turn anyway, so I'll go ahead and let you start. Thank you.
Mr. Copeland, are you there?
Yeah.
Okay, so we briefly spoke off the record, and I answered some questions about this agreement. Is that correct?
Yeah.
And do you understand it now?
Yes.
Okay, and are you currently in agreement with the agreement?
Yes.
Okay, and do you want the judge to render this agreement as a court order?
As in, yeah, sure.
Okay, I'll pass the witness, Judge.
All right, Ms. Bongat, any questions of the witness?
Yes, briefly, Your Honor. Mr. Copeland, when I announced to the court the amounts, I believe I may have misspoken when I said 1445 for current. Was it your understanding that it's actually 1435?
No, ma'am.
What amount did you understand it to be, sir?
I understand it to be 1435 for the current, for the next 2 months, and then 450. I think you said 444, like 450 for after that towards the arrears.
And actually, sir, the repayment amount of 445 was actually going to start at the same time if this court approves y'all's agreement about the $78,925 judgment.
I understand.
Okay, thank you, sir. Your Honor, I pass this witness.
All right, Ms. Griffin, anything on redirect?
No questions.
Anything on recross, Mr. Starr?
No, Your Honor.
All right, then, Ms. Griffin, call your next witness.
Thank you. I call Miss Kimberly Elo.
Yes.
Ms.
Okay,
Elo,
would
still
you-
take your full name for the record, ma'am?
Kimberly Maria Elo.
All right, thank you. You may proceed, Ms. Griffin.
Is it your understanding and your agreement that your child's father owes you retroactively $78,925 that he is paying on a repayment plan?
Yes, ma'am.
And is it your agreement that his current child support obligation is $1,435 beginning August 1st, 2024?
Yes, ma'am.
Are you in agreement with all of the other stipulations that Ms. Bongat provided regarding the testimony that she gave as to the amounts?
Yes, ma'am.
And do you agree to provide health insurance for your son and for Mr. Copeland to provide dental insurance?
Yes, ma'am.
Do you think all of those orders, in addition to you all having joint managing rights and visitation per your son's discretion, do you think all of those orders are in your child's best interest?
Yes, ma'am.
Are you asking for the court to approve our agreement and enter those orders when they're drafted?
Yes, ma'am.
Pass witness.
All right, then, Mr. Starr.
I have no questions, pass the witness.
All right, then, Ms. Bongat.
Briefly, Your Honor, thank you. Ms. Elo, was it correct, ma'am, that you had an opportunity to see the DNA test results, which were also filed with the court?
Yes, ma'am.
And you have no problem with this order reflecting that Mr. Brown is not the father of the child, but Mr. Copeland is?
Correct, yes.
And then, ma'am, as far as the source of your child's health coverage, what is that, please?
Tricare Select Reserve for retired.
And is that through you, ma'am, or another person?
Myself.
And you were comfortable, ma'am, paying any type of premium that's necessary for that coverage for your son?
Yes.
Thank you, ma'am. Your Honor, I pass this witness.
All right, anything else on redirect, Ms. Griffin?
No, no, sir.
Mr. Starr, Cross?
Nothing, Your Honor.
All right, folks, I'll agree to sign off on the final order on this matter. The court will find, based on the DNA test report that was filed with the court, that Mr. Vernon Copeland could not be exclusive biological father of the child. Probability of the paternity is 99.9999999. With a combined paternity index of 14.1 billion to 1, the court will so find that he is a biological father, prove the agreement for the current child support, the retroactive, the repayment schedule, and I will find that the presumed father in this matter obviously is not the father. And based on these circumstances, the court will waive court costs from either or any party, because technically I got 3, I guess. So the court cost is waived. So is there anything else at this time, Ms. Bongat?
No, Your Honor.
Okay, anything else, Mr. Starr?
No, Your Honor.
Ms. Griffin?
No, sir. Thank you.
All right. Thank y'all all very much. And we're off the record, and everybody try to stay cool out there. Thank you.